In Kano State, the government has imposed a total lockdown on the beginning from midnight, that's Thursday, April the 16th. Governor Abdullahi Ganduje announced this shortly after confirming the fourth positive case of COVID-19 in the state. According to him, the lockdown will last for 7 days at the first instance, with markets, mosques and churches to remain closed within the period. President Muhammadu Buhari's decision to extend the lockdown order in Lagos, Ogun and the FCT Abuja is generating reactions. While some Nigerians say the extension will inflict more hardship on people, others argue that it's a tough decision that must be made. A chief magistrate court in Port Harcourt, Rivers State, has granted bail to 2 helicopter pilots who were remanded for contravening the lockdown order and travel ban of the Rivers State government. Mr. Samuel Ugoji and Mr. Samuel Buhari, both pilots with Caverton helicopters, were accused of flouting an executive order of the governor, Nyesom Wike, to check the spread of coronavirus in the state. The court also granted bail to 10 passengers of Caverton helicopters who were flown into River State by the 2 pilots. The chief magistrate, in granting the 2 pilots bail, ordered that they must present a surety who must be on management staff of Caverton helicopters. He added that the surety will sign a bail bond of 1 million naira each for the 2 pilots and adjourn the matter till May the 19th for trial. When COVID-19 struck, many nations of the world, including Africa, were ready to continue business. Technological and other reforms also ensured that judiciaries of these countries were able to guarantee justice delivery. COVID-19 exposed the weakness in the Nigerian legal system as almost all courts in the country have ground to a halt. In continuation of our series of how the coronavirus pandemic is affecting crucial sectors of the economy, tonight we turn our attention to the judiciary, and our legal correspondent Shola Shoyele has this report.
By a circular dated the 23rd of March and addressed to all heads of courts, the Chief Justice of Nigeria, Justice Ibrahim Tanko Mohammed, gave the order for a partial shutdown of all courts across the country from the 24th of March as part of measures to prevent the spread of the coronavirus. The only exceptions were for urgent, essential or time-bound cases according to the extant laws.
And for me, each of the courts, with profound respect, each of the courts is headed by a head. There are laws, enabling laws, setting up the courts, the relevant provision of the Constitution, and the rules of court. The Chief Justice of Nigeria lacks the power under the current constitutional arrangement to lock down all courts in Nigeria.
Mr. Falana cites pending applications for the enforcement of fundamental rights, the need for a review of expired remand orders, and pending judgments as some cases which are awaiting the attention of the courts. Of course, there's also a loss of revenue. Apart from the budgetary allocation, the judiciary typically generates revenue from filing fees, penalties paid for late filing of processes, costs imposed by the courts on litigants and lawyers, and even revenue from the probate registry. Efforts to get figures from the heads of courts were unsuccessful, but many lawyers told Channels Television that the loss runs into several millions of naira.
People do not realize that the judiciary also generates income on probate matters, and probate alone it has been said has generated almost more than 30 million in a month. So it is very hard to say what kind of losses that the judiciary is suffering now, but they are enormous.
There's no doubt that the coronavirus pandemic has exposed the weaknesses inherent in the administration of justice in the country. While other countries of the world have introduced reforms that ensure that their court system continue to run without disruption in situations like this, the Nigerian judiciary has refused to evolve and embrace technology.
So the question is, with all these platforms available, why is it that the Chief Justice of Nigeria didn't say to himself, we have a crisis, we have a medical emergency which makes it difficult for us to meet physically, therefore I want to know what are the solutions we have? And someone has said, sir, have you heard of Skype? Sir, have you heard of Zoom?
The global health emergency which COVID-19 presents provides a great opportunity for the Nigerian judiciary to kickstart the process of reform by joining the rest of the world to digitalize its processes. It's therefore important for all stakeholders to give up their old ways of doing things and embrace the change that's inevitable. Shola Sheyele, Channels Television News.
To throw some more light on the impact of the global pandemic on Nigeria's judiciary, we're now being joined by Mr. Yemi Candid Johnson, a senior advocate of Nigeria. He joins us via Skype. Mr. Candid Johnson, a pleasure having you with us on the news at 10.
Thank you very much.
Can we actually quantify the impact of this pandemic on the judiciary?
Well, the judiciary is a resource that is provided by the people at their expense for their own use. So the proper question, I think, is the impact of the incapacity and inertness of the judiciary on the people. Now, if the function of the judiciary, as we recognize, is to decide disputes so that there will be peace and order and progress in society, then the real question is why the judiciary at this time should go into slump when there are still law and order problems, when there are still commercial contracts, when there are still issues of law that are in contest between people, and when we know that even though this is an existential crisis which affects all humanity, it will come to an end. There will be life after COVID-19. The question is whether in our attempt to deal with it, we lose the capacity to make progress across the board. I think that's what we're facing here.
Well, the CJN made it clear that cases that are urgent, essential and time-bound should be attended to. But some legal practitioners are actually questioning the powers of the CJN to shut down the courts. What's your view on this?
Well, there are two aspects. First of all, the question of naming items which are time-bound or time-limited is a very vague and insubstantial prescription. There's far more work that needs to be done to provide exactly what can be attended to, how it can be attended to. In my personal opinion, logistically, there's no reason why, with all the technology available, a single case which affects every single individual that comes to the court cannot be attended in the people's courts. As to powers of the Chief Justice, I have no doubt that the Chief Justice of Nigeria is in fact the President of the Supreme Court. He is the head of his own court, but he is in a position of cultural preeminence in the judiciary. He has a bully pulpit. He is able to give directions and to give examples which other judges and other heads of court can follow. That is actually his legal position. He should be an influencer and a leader of the judiciary. But as to power to direct courts, state, and other levels of court to suspend their sittings, I have no doubt he has no such power. If he considered the question carefully, he would realize that he did not have that power.
Like every other sector, there's bound to be some lessons from this pandemic. What do you think is the major takeaway for the judiciary?
For many years, we have realized that we were sitting on the outskirts of an industrial revolution, the fourth industrial revolution, the revolution which is going to unite technology and artificial intelligence and is going to take powers beyond human actors. At a conference of judges last year, I explained to them the paper was entitled Adapt or Perish. And I pointed out that computers can do 85 to 90% of the work that judges are doing today. The University of London created a computer program which was asked to run against the European Court of Justice. In 85% of the cases, it decided exactly in the same way as the human judges there. So the fact is that technology is overtaking a lot of the human activity, even in law. Law, like every other specter of human activity, is going to be disrupted by technology. So the lesson, in a time when we have cause to pause and when the weakness of our human resources and our human administration is being exposed, especially in the judiciary, which has completely lost its capacity to respond to the needs of the Nigerian people, then we should wonder whether this is not an opportunity to tag on to the advances of technology which will enable us to deliver the services which are promised by the law, by the Constitution, and by the oath that these judges have taken.
Senior Advocate of Nigeria, Mr. Yemi Candid Johnson, thank you for sharing your thoughts with us on the News at 10.